Hello, everyone, and welcome to another great webinar from CPA Academy. Thank you for joining us today. My name is Gabe, and I'll be your moderator for today's webinar, Rescheduling Medical Marijuana to Schedule 3, Review of the DOJ Ruling. Our presenter today is Justin Botillier. Before we get started, I wanted to go through some housekeeping items and do some technical checks just to make sure that everything is working. First, if you don't mind going to the Q&A tab on your control panel, and please let me know if you can hear my voice and see the title slide. Feel free to let us know one thing that you'd like to learn from today's webinar. And if anyone has any technical issues today, please let me know in that Q&A tab, and I will do my best to get around to everybody as quickly as possible. And this is also where you can post your questions and comments for our presenter. We do like to keep things interactive, so please use that Q&A. And as I look over, I see a lot of you using it as you're showing me it's working. So thank you so much. And now that we know that everything is working, let's go through some housekeeping. This webinar qualifies for 1 CPE credit, and CPE credit will be available within 24 hours in your CPA Academy account. This webinar will not have any polling questions. Instead, we'll be using attendance checks for your credit. The attendance checks will be randomly generated throughout the webinar. You'll see the image of a hand on a computer mouse on your screen. And when you see that image, just click anywhere on it, and it'll count toward your credit requirements. To earn credit today, you'll need to stay logged in for at least 50 minutes and respond to a minimum of 3 attendance checks. And there will be more than 4 generated per person, so you should have many chances in case you miss one. I also wanted to let everyone know that we're recording today's webinar, and the archive, along with your credit, will be available in your CPA Academy account within 24 hours. If you have to log out or log back in or refresh your browser for any reason, the webinar software will keep track of your time. And we also recommend you download today's presentation materials, which can be found in the control panel's handouts tab. So now that we're all set, let's welcome our presenter. I'm going to pass things over to Justin. Justin, the floor is all yours.
Thank you very much. Okay, so my name is Justin Botillier, CEO of Calyx CPA. We're a boutique CPA firm specializing in the plant medicine industries nationwide. Our primary focus or value-added service that we've done for over a decade now is essentially mitigating the effects of 280E or the impact of 280E. So hopefully you, at this point, if you're attending this webinar, you have some sort of idea what 280E is. It was kind of the thing that was put in our laps as accountants for those of us that are specializing specifically in the cannabis industry. And this announcement is pretty big in that regard because, as you have heard, they have essentially, the DOJ has rescheduled medical marijuana, amongst other things, and that's what we'll be talking about today. But it's not that straightforward. It is pretty robust. There's a lot of moving parts that went into this ruling, and so I'm going to try to touch on them throughout this presentation. Now, I have this slide deck. It's for you. It's full of information, way more information than I am probably going to be able to present to you today. I do webinars and I do presentations, speaking engagements on the topic, usually methodologies for mitigating 280E and reasonable bases and that type of thing. This is new for me, and I have a hard time with slides because sometimes I get ahead of myself. So please forgive me if that happens. So what's going to happen is I'm going to try to take it a little slow and go from slide to slide. This is not something I'm used to speaking on. This is brand new, only a couple weeks ago. And so I have taken time to try to synthesize the information as much as I can without having had the opportunity to present it as much as I usually do. As you may know, this is my third speaking engagement with the CPA Academy, so thank you so much. I spoke on psychedelics, and then I spoke on the New Mexico Top Organics case, which I will probably refer to. But this is very unique. And so I hope you I hope you enjoy. So a lot of the information in this slide deck, and you should be able to download it, and came from, it's not only the DOJ order itself, but then also the Congressional Research Service's congress.gov posting. If you go to congress.gov, this organization called the Congressional Research Service, which is interesting. It's like the department that it's like a independent legal agency that all of the Congress people rely on to help them write bills and to synthesize information and to summarize information for the general public. It's actually kind of interesting. And the congress.gov, you can find it at congress.gov/CRS product, and they have a huge library of information on all the different bills and the goings on with the federal government. And they synthesized that DOJ order down. And so, disclaimer, I copied and pasted quite a bit from that into this. So if you see big bulk sections with wording, I'm just telling you now that the resource is probably that. And then, of course, I use Chat GPT and Gemini. I don't think it's smart to not use it nowadays because the information is so easily available, and it's such a useful tool. So I'm just letting you know that. And then also, I like to talk about law, but I am not an attorney, and I am not qualified to practice law. So none of this is legal advice. I have been accused of practicing law, and I didn't mean to. I just enjoy going through legal briefs and stuff. Okay, so let's begin. Now, before I get into the nit and gritty of the order itself, I want to do a shout out to Kim Rivers, the CEO of TrueLeave, which is a large MSO cannabis operator, primary medical out of Florida. And if you know her, give her my number. I'd love to have a conversation with her because she's so interesting. I've heard her speak before, but I wasn't ever able to pin her down to just say hello. But anyway, I would say that she's responsible for blowing the lid off of all of this. Back in 2023, TrueLeave, so she's been the CEO of TrueLeave for quite a while. There was a big article and a big announcement that they received $113 million in tax refunds. And that began kind of the wave of people amending their tax returns to recapture lost deductions due to 280E. And the reasonable basis for doing that was all very speculative. They kept it very close at hand, but it was enough to give us, our firm, the courage to move forward with amending tax returns as well and recapturing lost deductions and disputing and challenging 280E, whether it is constitutional or whether cannabis doesn't fit the meaning of a Schedule I substance. And this is all super interesting because this is a spin, man. I did not see this happening the way it did. I knew that something was gonna get rescheduled. It was gonna get rescheduled, but I thought it was gonna be an all or nothing thing, not, hey, half and half thing. So, okay. And so then she's also the person responsible. I don't know if you guys watch the news, but she truly contributed to Trump's campaign and got him elected. Okay. Helped him get elected. Now, I'm not saying that was a good or bad thing. I'm being indifferent politically, but ultimately they contributed to his campaign. He got elected. And then Trump ignored cannabis and didn't make good on his campaign promises. But then she pinned him down at like a fundraiser with a journalist witness and told him, hey, are you going to make good on your campaign promise? And then, of course, he was like, well, I guess I am going to. So he told her, yes, we're going to make good on the campaign promise. So good for her. And the reason why I'm also bringing them into it is because when we get into it, I'm going to circle back around on TrueLeave's role in this and my speculation as to what that might be, even though I don't know if I don't know what the truth necessarily is. Okay, so on April 23rd, 2026, the DOJ passed this final order. Specifically, the order provides that marijuana and its derivatives are now controlled in Schedule 3 under the CSA, Controlled Substances Act, to the extent they are included in a Food and Drug Administration FDA-approved drug product or are subject to state-issued license to manufacture, distribute, and or dispense marijuana or products containing marijuana for medical purposes. So essentially there were a couple, so FDA approved products. Okay, so if it's FDA approved, that has now been rescheduled, and also states that have a medical marijuana license. Okay, so that's interesting because sometimes people are saying, well, they rescheduled medical marijuana only to the extent that they have a medical marijuana license. So it's intriguing. And again, I don't want to get ahead of myself. We're going to have plenty to talk about. I'm going to try to stay on task here. What it doesn't do does not affect adult use cannabis, hemp, unlicensed bulk marijuana, synthetically derived THC, or previously rescheduled products. So there are a couple of prescriptions that are cannabis-based, or THC is the active substance. It's Schedule 1 or Schedule 2 or 3 right now. It does not reschedule those to Schedule 3, but it does reschedule FDA-approved products and state-licensed medical marijuana. That's an important distinction. I think people were saying that, well, medical marijuana has been rescheduled. That's not true. Farms that are selling medical or companies that are selling medical marijuana under a state medical license, that is what was rescheduled. Okay. So let's go back a little bit. Let's do a little history because I want you. It's interesting. The Controlled Substances Act was enacted in the 1970s. There was kind of a smattering of drug policies. They kind of brought it all together, and they wanted to create this comprehensive scheduling process called the Controlled Substances Act. They wanted to take all regulated drugs, and they wanted to schedule them based on certain things, like Schedule 1 is highly addictive, highly dangerous, no medical benefit. 2 is has a medical benefit, isn't dangerous under supervision. 3 is, it's not, it's okay. One thing I want to point out, though, is that besides Schedule 1, all of the other ones are FDA approved. So this is really interesting because when the DOJ did this rescheduling, so say licensed, so what they're saying essentially is that the medical marijuana being sold under a state licensed program is now FDA approved in a way, I guess, because if you look at some of the drugs that are on here, of course, Schedule 1 and Schedule 2 are the debatable ones. 280 applies to all of that. They're the ones that are very high risk. We know cannabis doesn't fit that, right? But look at what Schedule 3, Schedule 4, and Schedule 5 is. Ketamine, steroids, testosterone, codeine. These are FDA approved for prescription. These are FDA approved prescription drugs. So I just find that compelling because what they're saying is that they're almost having to rewrite the thing because marijuana flower is not FDA approved. And so now for it to be a Schedule 3 substance, it's the only one in there that's not FDA approved. And so it's kind of like, that's why it's kind of, this whole thing is a little bit of disjointed and I didn't even realize this. I have been so focused on mitigating 280E, finding reasonable basis for why cannabis is, reasons why cannabis has been misscheduled this whole time. Well, guess what? there was no place for cannabis to go. We've been saying, oh, cannabis is a Schedule 3 substance. It's not a Schedule 1 substance. Well, actually, it's not. It shouldn't even be regulated under the Controlled Substances Act, period, because it's not FDA approved. It's more like tobacco. It's more like alcohol. It's, those are not on the controlled substances list because they're regulated, but they're not one of these. They don't fit here. And so it's kind of interesting that. Okay, so I'm going to kind of go on another little tangent. What is not marijuana? The CSA definition of marijuana excludes products that meet the legal definition of hemp, the mature stalks of cannabis plant, the sterilized seeds of the plant, fibers, oils, and other products made from the stalks and seeds. And I don't know if you guys want to learn a little bit about hemp and the whole THCA thing. We can talk a little bit about that because that's kind of interesting. So hemp is currently defined as the cannabis plant or any part of that plant with a concentration of no more than 0.3% of the psychoactive cannabinoid delta-9 THC. Okay. In November 2025, Congress enacted legislation changing the definition of hemp so that, among other things, it is defined based on the total THC concentration rather than just the concentration of delta-9 THC. So what was happening was when the Farm Bill passed, okay, it just said that cannabinoids were hemp unless they had a THC concentration of 0.3 or below, or no, higher. So meaning what the Farm Bill excluded from hemp was simply high concentrations of THC, period. Now, Oregon, where I'm at, got pretty quickly to the fact that there is also what's called THCA. And now THCA is the precursor to THC. And it only becomes THC when you combust it. So Oregon changed its rules and said, okay, we're going to require a concentration of 0.3 total THC and below. And that is what hemp is. But most of the states did not do that. So then they created an incredible national market for essentially what they called intoxicating hemp. And where that got a lot of traction was in the Midwest states and the southern states, because the hemp people were using the hemp rule as a loophole in order to grow and sell marijuana across the United States. And that has been very interesting. And I don't know if that plays in this a little bit, but I do know that there were a lot of ballots for adult use marijuana and also creating a total THC, program in various states that got vetoed relatively recently. So it's kind of interesting. I think I had more to that, but I think I forgot what my point was going to be, so I apologize. But another thing that Congress.gov, or the service, the congressional service, the legal department there, pointed out was that, interestingly enough, the Attorney General has the authority to schedule controlled substances via administrative rulemaking. So that's like going through a process of administration. But there's also some language in the Controlled Substances Act that will allow it if a substance needs to be scheduled, he can just schedule it. So Todd Blanche can just schedule it. And that's kind of what happened. But they have to comply with these international treaties, and I'll go over what those are here pretty soon. But the thing that I wanted to point out is that Congress actually has the power to do anything it wants. If it wants to decriminalize or deschedule cannabis altogether, it has the power to do that. And what it could also do, depending on how things roll out and how conservative Congress is, they could just make 280E apply to any substance, no matter whether it's legal or not. And so if they wanted to come back and say like, hey, you know what, 280E applies to marijuana, period, even if it is a Schedule III substance, they can write that in. And as you know, like the federal government trumps the states. So even though the states may have their own drug policy, whatever the federal government says that that's the policy that trumps the state's policy. So then one of the things that has really allowed the states' programs to survive is this rider that Congress has passed. It's called the appropriations rider, barring the DOJ from using taxpayer funds to prevent states from implementing their own laws that authorize the use, distribution, possession, or cultivation of medical marijuana. The reason why I'm pointing this out is that medical marijuana is not legal. That's what I'm trying to get at. It's not legal. The programs are still very much illegal. It's just that if you have a medical license, then you're trafficking in a Schedule III substance, and therefore 280E applies. That's really the only thing that has changed there from that perspective. Okay, and then and so then people are kind of wondering, well, what about adult use? What's going to happen there? Well, let's start at the beginning. I mean, in 2023, the Biden administration, with that letter from the HHS telling the DEA, backed by a 250-page paper from the FDA telling the DEA that cannabis solidly fits the criteria of a Schedule III substance and should be rescheduled, they started the administrative proceedings to reschedule cannabis at large. Okay, but then the proceeding, there were opponents to it that started to muddy the works, and in fact started to be kind of there was some shenanigans involved, and that made those administrative proceedings take longer and longer. And the judge, like, I don't know what the judge was not like punishing them or saying, hey, we're going to move rescheduling along faster because you guys are making a mess of this. Instead, he's like, we're just going to pause the whole thing. And then ultimately, as they transitioned from the Biden administration to the Trump administration, they just threw the whole thing out. So I felt like those people who were, were messing with the system, that the judge pointed out and said, hey, you guys are doing bad things here. They won. They got what they wanted. And so then it stalled. And then they're like, okay, well, now we have to wait for the new attorney general. And so then Trump was elected. Pam Bondi was elected attorney general, and she just sat on it, did nothing for a long time. And then finally Kim, the CEO of Trulieve, cornered Trump, said, hey, you got to make good on your campaign promises. And then nothing happened. He did that executive order, and the executive order was to start the administrative process again back in May of 2024. Let's start the administrative process again to reschedule cannabis. But then Pam Bondi just sat on it for months and months, and people were like wondering, okay, what's going to happen here? And then Trump replaced Pam Bondi with Todd Blanche, who was his former personal attorney. I'm not sure what Pam Bondi's relationship to Trump is, but Todd Blanche is was his personal defense attorney, and he made it happen. He got it going. He did it, right? So interesting. So here we go. And then for adult use, in the order, it says that the new hearings are going to start in June. I thought they were going to end. And so this slide may or may not be accurate. No, they're going to start at the end of June and then finish in the middle of July. So in a couple of weeks, they're trying to promise. Okay. So I'm going to get into now. I'm going to get into some of the nuances of this ruling. So it's not just as simple as okay, now medical marijuana is a Schedule III substance. Period. There is more to it. Are these like international trade treaties, and so I wanted to bring up this guy just for anecdotal fun. Harry Anslinger back in the 30s. He started in government in the 30s, I think. I don't know a whole lot about him, but he was really one of the proponents for really rigid drug policies and kind of on the tail end of prohibition. I think, I don't know, the police needed something to do because they stopped having to fight the organized crime, rings and the gangs and stuff. And so they're like, hey, let's go after other people. And so essentially they created, he was, okay, so I'll just read some of what he did here. First commissioner of the FBN, later the DEA. That's the Federal Bureau of Narcotics. That's what it used to be called. And now it converted to the DEA. So he was one of the first commissioner. Promoted punitive federal drug policies from 1930 to 1962. Sensational claims linked cannabis to insanity, violence, and moral decline. So all of the reefer madness stuff was really pushed by him. Helped drive the Marijuana Tax Act of 1937. Used racialized and anti-immigrant rhetoric against Mexican immigrants, Black Americans, and jazz culture. Influenced harsher 1950s penalties and the Controlled Substances Act. So he's the guy who did this. And one of the things that he also did kind of on the later end of his career is there was an international push to consolidate and put together a more national oriented drug policy. And they called it the 1961 Single Convention Act. I think it actually had a bigger name than that, but ultimately in there they classified cannabis in there as a controlled substance, and it was treated as one of the worst. And when I was reading a little bit about it, like the history about it, it's kind of interesting because you had like Europe that had a very large pharmaceutical industry, and they were very concerned that, hey, we want to make sure that our drugs can be sold nationally, internationally. But then the U.S. is like, and Russia were of the same mind. Well, we want drugs to be controlled and pressed down. And then you had the Central America and some of these poor nations, so the Middle East, that provided the raw materials for these drugs. And so it was kind of a bunch of pushing, pulling from each of these groups and they ultimately ended up on this single convention rule. So one of the things that had been brought up many times over the years when they were trying to, when advocates of cannabis rescheduling were trying to get the DEA to reschedule, they would always go back to the single convention treaty and say, well, we can't do it because we have to comply to that. And if you want a really good like domestic history of what was going on back in the day, the last 50 years, how various organizations like NORML had sued the DEA to take into consideration that cannabis didn't fit the criteria of a Schedule I substance and tried to get them to reschedule or deschedule, and how for 50 years the DEA just blocked any of that and came up with all sorts of cockamamie excuses, even in the face of judicial demand. So like the judge would find favor in or rule in the favor of NORML and these other organizations that would sue, saying that cannabis was misclassified. And then the judge would tell the DEA, you need to really take this seriously. And the DEA would just give them the finger, essentially. So this amicus curiae brief is really interesting. It goes on the back of this. It's in support of New Mexico Top Organics. That is the petition that is being litigated now that is arguing that cannabis doesn't fit the meaning of a Schedule I substance and therefore 280E doesn't apply. Today is the day that Nathaniel Pollock, who is the author of that petition representing New Mexico Top Organics, is supposed to include his response to the IRS's response to his petition. It's like a courtroom drama. I just like it. It's very interesting. And this brief is in support of the New Mexico Top Organics case, and it is excellent if you want some really good reading. If you want to hear a summary view, you can watch my webinar that I did for the CPA Academy last. Okay, so this is a lot of words, but essentially the DEA, the DOJ, the Office of Legal Counsel, the Office of Legal Counsel is an independent legal agency that operates under the DOJ to decide what is right and what is wrong, I guess. And they concluded that the DEA's ruling or the DOJ's ruling to reschedule cannabis meets all the criterias of the Single Convention Treaty. So we're good, essentially. There's only one that it doesn't, and that has to do with import or export of covered drugs, which I guess they're going to work on that later. But let's get to this. This is the weird thing. One of the things that the DOJ's order does is it requires a new registration process for the licensed medical companies, the state licensed medical companies, to register with the DEA now, because to comply with the Single Convention Treaty, there's a requirement for these drugs to be somewhat monopolized, I guess. I guess if they're a certain level, then they have to be monopolized. I don't fully understand it myself, but there has to be kind of a monopoly on it, meaning like it has to be highly controlled by the federal government if it's going to comply to the treaty. And so the DEA set up this interesting like registration process where if you have a medical license, you register with the DEA. And I guess the intent is going to be that it's going to be like an off the books journal entry. I can talk to you guys about journal entries. There's no actual money changing hands, but essentially the DEA is going to buy the product and then resell it back, less an administrative fee. So I think it's like that's kind of a backdoor tax that the DEA is going to create. And right now they've already started the process. You can like go and register if you have any clients that are cannabis operators, or you're a cannabis operator and you're medical license, you have a medical license, you should go register. Some people are saying don't register, but I'm like, go register, get involved, like because from my perspective, they're setting up a opportunity for interstate commerce that's going to be highly regulated by the DEA. But it will allow interstate commerce nevertheless, I think, or I could be completely wrong. But the reason why you guys are all here is 280E, of course, the tax, and what are we going to do about it? What does it allow us to do? And then we're waiting for guidance from the Department of Treasury. They did not say when they're going to provide guidance, but to reiterate, what we need guidance on is that, again, the ruling says if you have a medical license. So I'm already like kind of looking at it more liberally than what I think the IRS might look at it as. Like, I think from a more conservative perspective, they're going to say, well, you're going to need to bifurcate so if you're a medical license only and you're only selling medical marijuana, no 280E, congratulations. But that's only 30% of the industry. 70% of the industry is either adult use or dual, right? So that leaves a lot of people wondering and hanging out there. But But if I were the IRS, I would say, okay, well, if you're dual use, if you're a dual license, then you need to bifurcate your expenses. And you can do it based on sales, for example. And I know some states are doing this, right? States do this. So they'll allow a subtraction for the non-medical, and then they for the adult use, but then they don't allow a subtraction for the state. It's crazy, and I don't know why that's still that way, but some of the states have it that way, where they have to bifurcate the expenses. And then, of course, you file income state tax returns for the cities and whatnot, and you have to figure out, okay, what was my sales in this city and what was my sales in that state? And now I have to allocate some of my expenses to each of those. So they know we can do it. They know that we do it, and they can do it. So they're not going to probably be easy on us and say, like, you know what, 100% of your deductions, if you are a dual use or a dual licensed entity, then you can not reduce your deductions for 280E. That's probably not going to happen. They're going to probably make us bifurcate it. And also, I think they're going to probably wait to see what happens regarding these administrative procedures, to see if we can get adult use across the finish line and make it not subject to Schedule 3. It doesn't make a lot of sense that it's not now. It's the same flower if you're if you're a medical license. So it is. So that's what's really interesting to me, is the DOJ specifically said that if you've got a medical license, and so if you and that kind of makes sense, because if you're selling the same product and it doesn't matter, like the same flower could be bought by a regular customer, or it can be bought by somebody with a medical card, right? And it's the same stuff. So why would that be considered Schedule 1 and not Schedule 3? Or so it's really confusing to me there, and we'll see what the IRS has to say. I imagine they're going to kick this guidance down the road until after we can see if we can just get all of it rescheduled. But I'm not absolutely sure if it's going to get rescheduled. I kind of feel like it's a 50-50 just based on history. All right, that was a lot. Let's see here. Oh, see, I got ahead of myself here. This was me kind of speculating on most conservative, middle ground, more tax favorable, less tax favorable. But one thing's for certain, the adult use market is just, they're holding the bag. Washington, Oregon, California, Colorado, Michigan, all the old school people, Alaska, even like some of the newer ones in New York on the East Coast, most states, specifically the more liberal states, the left-wing Democratic states, are the ones that have an adult use, like, hey, let's just legalize it kind of attitude about it. Whereas the Midwest states, like Oklahoma was an early Midwest state, it's all medical. There's no rec. Florida shot down its rec. It's all medical. So that's one of my conspiracy theories, is that Trulieve is more of a medical MSO. It's based in Florida, which is only a medical state. And if you look at the demographics of the states that are just medical programs versus medical and adult use, or just adult use, you'll see that they're conservative states. So if I were Trump and I wanted to throw my constituents a bone, I would try to hold off on allowing adult use to participate in the federal program as long as possible, and even make it so that 280E still applies to those states, right? It's a good way to harm us. I'm in Oregon. It's a good way to harm us. So hopefully that's not the reality of it. Hopefully they're going to be fair and judicial, but I don't know. It's hard for me to believe that. It's hard for me to believe. Okay. So another thing that the order said was that the Attorney General also in the order told the Treasury Department, please consider, it was kind of a request or an encouragement, we encourage you to allow medical licensed operators to amend their returns and recapture lost deductions due to 280E. So now the IRS hasn't said anything about that, and it was encouraged. One thing is for sure that 280E, and I think it said it in there, that 280E, or at least in the regulation, the little bit that the Treasury Department did say when it was kind of just saying, hey, we're going to give you some guidance later. What it did say was, in the year that rescheduling happened. So for 2026, if you're a medical licensed company, then 280E doesn't apply to you. And there is a potential of going back and amending. Now, personally, I would just start amending now ahead of time, because the statute of limitations it's 2022 right now. We're amending tax returns for 2022. So get in there, like amend these returns, put in a disclosure, say, hey, like we want to go ahead and put this amended return in now, so that when we get guidance that says that the medical industry can amend returns for refunds, they're there, right? If you wait and they kick that can down the road, then the statutes are going to close for that, and then you're probably not going to be able to get it back again. As far as like the mixed licenses getting to go back and amend, they might allow it. Again, I would just be proactive and do it anyway. And that's a different webinar. Go watch my New Mexico Top Organics webinar, and then I'll talk to you about the reasonable basis for amending returns, regardless of what license type you are. Of course, they're not going to condone adult use, only licenses to amend their returns. So this is what, okay. So back to this, and again, I got ahead of myself. I was starting to talk about the FDA program. In my mind, the FDA or the DEA is setting up the possibility of interstate commerce for the medical program, for the medical participants. Even the governor of Oklahoma right now is encouraging their medical licensees to go get registered with the DEA instead. In fact, they made it a requirement. If you're going to continue to operate as a medical license, you need to go register with the DEA. And I have a feeling that those companies, Oklahoma and Friends and True Leaf and Friends, they're going to benefit somehow. Like somehow this is going to end up in like, hey, now Oklahoma can be like the raw material provider of the medical program. And then right now the registration process is allowing dispensaries to register to be able to legally dispense medical marijuana under the DEA program. And that's really interesting to me because I'm in Southern Oregon, and Oregon is a huge outdoor producer here. We grow a lot of outdoor high quality cannabis. They are kind of quasi gray market. They do provide a lot of the raw materials for the THC hemp industry and whatnot. They really want a legal way to be able to cross state lines, but the DEA is not going to allow them to get in easily, I suspect. But one of the things that people should think about, your client should think about, is now they are a Schedule III substance, essentially kind of like an FDA Schedule III substance. So it's kind of something to think about. I'm on slide 23. I'm going to go back to slide 7. So, these schedules, Schedule 3, 4, and 5, they all have a lot of regulatory requirements, right? Because these are all, so now it's not just that, hey, comply to your state license. They may have to consider like, well, what goes into being a Schedule 3? And then who's the authority here? Before it was the state was the authority, but now the DEA is the authority, right? So it's kind of like, ooh, interesting. Like now there's a whole other framework that they may have to comply to. And it's probably a really good idea to get to know the Schedule 3 regulation. Okay. Adult use is still Schedule 3 or Schedule 1.
Device disconnected. No device.
I think that is, and then we have to wait for the new hearings starting June 29th for for adult use to be rescheduled. I think that's about it, guys. There's a lot of loose ends here. What it didn't do, I like this little list at the beginning. It created relief for medical marijuana licensing, especially for 280E purposes, but it leaves adult use cannabis unresolved. It leaves mixed use allocations unresolved. It leaves interstate commerce unresolved. It leaves FDA compliance unresolved. So there's a lot more questions that have to be answered here before we're able to really know conclusively how to address this. All right, well, great. It's 2:45. I've got 15 minutes. So why don't we answer some questions? Let's see here. So Q&A, where marijuana taxes are lowest. I don't know what that means. Where marijuana taxes are lowest.
I guess he was probably wondering which state has the lowest taxing. I'm not sure.
Oh, yeah, I don't know. That's a hard one. That's a very nuanced question. So if I have time, I'll go back to it. Is it retroactive such that we can amend prior year returns? So I did cover that. We cannot amend tax returns right now. Medical got rescheduled in 2026, and therefore for medical licenses selling medical marijuana, 280 does not apply to you or to them in 2026, period. The Attorney General asked the Treasury Department to allow amendments, but the IRS and the Treasury Department have not provided guidance on that yet. Why do you think they received a refund? The amended returns have all been denied. Why? Well, no, that's not true. The amended returns have not all been denied. Amended returns are being accepted by the IRS in droves. I'm not exactly sure why. There's quite a few of them that have been denied, but a lot of them are getting through, and including Truly for $113 million. So there was some sort of reasonable basis that got them through and got them their $113 million. It might have been kind of like, hey, you know what? We would rather not pay you interest on this if you end up winning your court cases or whatever, and the reasonable basis that you use to amend your return actually gets ruled in your favor. The IRS was like, well, we're just going to give them the $113 million, because if we have to give them $113 million later, we're going to owe a lot of interest on that. That's one hypothesis. To me, it meant that there was some really good arguments that we should not proactively pay tax on phantom income. We should keep that money, or we should amend our returns and get our money back, because it definitely is up in the air. And this is going to win that New Mexico Top Organics case, in my opinion. Again, that's my opinion. I think that them coming through like this and saying, you know what, medical marijuana is a Schedule III substance at this point. That's kind of the whole case for New Mexico Top Organics. So it kind of concerns me a little bit, because they could just say, well, yeah, you win, New Mexico Top Organics. We're going to give you your refunds for because you're a medical license provider, but you adult use people go to hell. You know what I mean? All right. Let's see. So only for medical use and not recreational use. I'm so sorry if I didn't get to the point. I was trying to follow the slides. Usually I'm a little bit more to the point. But yes, medical use. And remember though, it doesn't say medical marijuana. It says if you're a medical license, So you could interpret that. Maybe you can interpret that favorably and say well, that includes everything, because I have a medical license, even if it's adult use. And it is the same substance, right? Whether you're a medical card holder or not, you're buying the same substance. So why is it one Schedule I and the other not? Why is one Schedule I and one Schedule III? That doesn't make any sense. It's the same flower, same stuff. But I bet the guidance will say otherwise. I bet the guidance will come in and say you have to bifurcate or something like that. What years can be amended? 2022 and going forward, or if you have 3 years from the due date of the return. So right now it's 2022. You can amend your returns right now. So if people were on time with their 2022 returns and got it in before the April 15th deadline, then it's of 2023. Now it's too late. It's beyond the statute of limitations. But if your clients were filed their return for 2022 in like October of 2023, you can amend those returns. And then of course, going forward, 2022, 23, 24, and now 25, we can amend those returns. What about recreational marijuana, whether they are released from 280E regulation? They are absolutely not. They are not released from 280E. 70% of the industry is still is adult use, recreational, adult use and recreational cannabis, the same word, not same word, same meaning, and 280E still applies to them. So again, I encourage you to maybe look at the webinar that I did with CPA Academy last time. I don't remember when it was, but it was relatively recently. And I go over the New Mexico Top Organics case, the IRS's response, reasonable basis for amending returns, saying that 280 doesn't apply, proactively not paying tax on phantom income, amending returns to get your refunds now ahead of rescheduling. You have a reasonable, it's our opinion here at Calyx that you have a reasonable basis to do that. Let's see. Thanks for the great info. What specifically are you amending on the returns? Are you going back and fully claiming all operating expenses? So yes, we are. We have a 3-page disclosure that we got the assistance of an attorney to write up. 8275R or 8275. We put that in there. We list specifically the deductions that would otherwise be disallowed by 280E. And we send that off and say, we're taking those and we're not going to proactively pay tax on the phantom income, or we go back and we ask for a refund. And the success rate is in that other webinar if you're interested in that. Are any members of Congress known to use cannabis? That's a fun question. And I don't know. Of course, none of them would admit it, right? How did Trulieve get her Fed refund already if the process for refunds was only recently declared? I know, right? No, I mean, you can amend, you can challenge the IRS, because you got to remember that the IRS doesn't write the tax code. They do two things. They enforce the tax code and they provide guidance when there's ambiguity in the tax code. So, so you can challenge them. You can challenge their interpretation of the tax code. There's a whole apparatus in the tax code to challenge the IRS's interpretation of the tax code and argue in a different way. Now, those refund requests could get denied, and they do get denied, which then requires like an appeals process, or you got to take it to tax court. But that's something that you're allowed to do. You can at least try. And then if you don't want to put up a fight, you don't put up a fight. But if you want to fight, you fight, and you can do that. And there's also an extension. I think it's a 709. So maybe they deny your refund claim, and then you ask for an extension until after there's resolution in these tax court cases, or after these arguments that we're presenting have finally concluded. But you can certainly ask. You can definitely, it's absolutely legal to amend. And there's this worry that you have to have a really, really good reasonable basis. But guess what? It only has to be like 20% chance that it's going to win. And as long as you're using like kind of statutory language, maybe some court cases, maybe some federal conclusions, like for example, the HHS writing a letter to the DEA saying that cannabis is not a Schedule I substance, it's a Schedule III substance. You can say, well, hey, this has been miscategorized and 280E doesn't apply according to the statute, the the statutory language of 280E. And again, I have many webinars talking about that for sure. Let's see. Are the majority of marijuana business owners filing Schedule Cs or S corps? And then there's Therese. Are the majority of their sales in person or online? Interesting. I would say that the majority of businesses are C corps, at least dispensaries, because as you know, Schedule Cs and S corps and partnerships are all pass through. We don't like that necessarily, because if the IRS comes back and decides that they want to make a spectacle of you, they can make a big adjustment and then they can bury you personally in tax debt. We don't like that. Certainly if you're like a cultivator or a processor and you can justify a lot of your expenses as direct costs, then you could say that those are cost of goods sold. And then you're just debating over some office expenses, maybe some professional fees, those types of things. You could take the risk at being an S corp, I would say. I don't really like Schedule Cs. I avoid those, like in any business, any legal business. I'm a big fan of the S corp. You got the, it separates you from your business. You've got a lower audit profile if you're an S corp. Then you can also reduce your self-employment taxes, all that good stuff that an S corp allows you to do. But C corps can also be tax beneficial. People sometimes don't like C corps because of the double taxation and all that stuff. Double taxation. But you can avoid double taxation if you manage the business properly. You can have a rental, like a real estate holding company that you can put money through. You can have other companies that are providing services. Maybe the management is a management company. You can move money through it, and that can be that can be where distributions are taken, through the services of the management company or the personnel company or anything like that. There's ways to mitigate the double taxation thing. And then sometimes people just are okay with double tax, the dividend, it's making enough money. There's lots of investors, lots of shareholders. We'll just do a dividend call and send them all a check. Okay. Let's see. Are the majority of their sales in person or online? I would say that only delivery is legal at this point. There is hemp. Hemp has been online. Like hemp has a big online presence. Pretty illegal. It's pretty much illegal, but it's there. And some of the states are defending their hemp industries. And a lot of those companies are online, but the adult use or state licensed medical programs, they might allow online orders, and then you deliver, and then they get delivered. But I don't think that illegal substances are allowed to be shipped in the U.S. Postal Service. So I doubt that. I doubt it's online. So mostly dispensaries and whatnot. Does this open up relations with banking? It's still not an FDA approved federally legal thing until you get registered with the DEA. I imagine the banks will get more confidence than they used to. But I don't, until something like the Safe Banking Act passes, and Congress is like, go ahead, you are protected, then banks are going to be cautious, and then the cannabis businesses are going to still pay enormous fees for banking as they have for all of these years. Okay. Perhaps I misunderstood. Are you amending non-medically licensed dispensaries? The answer is yes, we are. And I would highly recommend watching the other webinar that I did not too long ago. I think it could be very useful. And then, of course, go to our website and get on our email list. And I periodically do like webinars just through Calyx and whatnot.
All right. Well, thank you so much, Justin. We really appreciate having you here with us today. And so to wrap things up for our attendees, the handouts, archive of the webinar, and credit will be available in your CPA Academy account within 24 hours. And if you look in your email inbox, you'll also find an evaluation link for this webinar. So please let us know how we did. All questions that were asked today will also be forwarded in a full report to our presenter as well. Thanks again to Justin for your excellent content and to our members for participating today. Please check the schedule on our website for additional information, and we hope to see you on a future webinar. Have a great day, everyone.